Good day, everyone. I'm Abigail Osana, 19 years old, from the College of Bachelor of Science in Accountancy, and I'm here to discuss the continuation of report. In this presentation, we will tackle about the continuation of Article 1831, which is on the application of the purchaser of a partner's interest. Next is Article 1832, with respect to the partners, and with respect to the person not partners, as declared in Article 1834. Next is Article 1833, and last is Article 1834. Partnership is liable and partnership is not liable. We will now discuss first the continuation of Article 1831, which is the application of the purchaser of a partner's interest. A purchaser of a partner's interest under Article 1813 or 1814, after the termination of the specified term or particular undertaking, or if the partnership is at will when the interest was assigned or when the charging order was issued. Ang Article 8, ang continuation nito is nagpo-focus siya sa rights ng purchaser of a partner's interest. Kung natatandaan natin yung Article 1813, ito yung effect of assignment of partners whole interest in partnership. It pertains to the purchase of the whole interest ng partner sa isang partnership. Ang Article 1840 naman is remedies of separate judgment of creditor of a partner. Dito naman, basically pertains to redemption and separate credit of the partner. We have here an example. A, B, and C form a partnership to continue for a term of 5 years. On the 3rd year, C sold his entire interest to D. Under Article 1813, such conveyance does not dissolve the partnership, and D does not become a partner, his only right being to receive the profits to which C would otherwise be entitled. Hence, D cannot ask for judicial dissolution of the partnership. Since binenta daw ni C kay D ang interest niya sa partnership, hindi madidissolve ang partnership since tinransfer lang niya yung interest kay D. Ngayon, yung si D, meron na siyang rights na makareceive ng profit dahil nabenta na nga sa kanya yung interest ni C. However, if after the 5th year the partnership is continued, D is entitled to ask for judicial dissolution. The partnership as continued may or may not be a partnership at will. Hindi pwede mag-ask si D ng dissolution since 5 years yung contract sa partnership dun sa partnership ni C. Kung matapos man yung 5 years na contract na yun, dun lang siya pwedeng makapag-file ng dissolution since tapos na yung 5-year contract. As we proceed to the next slide, Article 1832 talks about the effect of dissolution on authority of partner. Except so far as may be necessary to wind up partnership affairs or to complete transaction begun but not then finished, dissolution terminates all authority of any partner to act for the partnership. Kapag daw in the process of dissolution na ang partnership, the only thing can be done is to complete the transaction na nasimulan na before mag-dissolve with respect to the partners. As the partners concerned, when the dissolution is not by the act, insolvency, or death of a partner, the authority to bind the another transaction is immediately terminated. Next is when the dissolution is by such act, insolvency, or death, termination of authority will depend on the knowledge or notice of dissolution. With respect to person not partners as declared in Article 1834. When the dissolution is by such Without the knowledge of termination of authority, the innocent partner can recover from the acting partner. We have here example. A, B, and C form a partnership. If today the partnership is dissolved, then any of the partner must not enter into contract because it is no longer binding the partnership. Sabi dito, as a rule, when a partnership is dissolved, any of the partner cannot bind the partnership. Pwera na lang if the transaction is for the purpose of the liquidation. Basically, ang sinasabi lang ng 1832, after ng dissolution of the partnership, ang kailangan mo lang gawin is to wind up the affairs, settlement of the account, and complete any unfinished transaction that was started before the dissolution. On the next slide, we have here Article 1833 that provides where the dissolution is caused by the act, death, or insolvency of a partner, each partner is liable to his co-partners for his share of an liability created by any partner acting for the partnership as if the partner had not been dissolved. Sabi dito, yung nag-cause daw ng dissolution is by the act of partner o kaya naman yung pagka-bankruptcy. And with that, my partner acted for the partnership, and with that, the act of partnership bind the partnership and partner as if di na-dissolve ang partnership. Unless the dissolution being by act of any partner, the partner acting for the partnership had knowledge of the dissolution. Dito naman, yung nag-cause ng dissolution is yung partner na nag-act in bad faith. And yung acting partner is may alam, kumbaga, may knowledge siya sa ginawa ng partner niya. On next exception is the dissolution being by the death or insolvency of a partner. The partner acting for the partnership had knowledge or notice of death or insolvency. Dito naman, whether knowledge or notice, it will take to effect na hindi mabind ang partner. Bali, ang purpose ng 1833 is to protect the innocent partner. We will now go to the last article, Article 1834, which after dissolution, a partner can bind the partnership except as provided in the third paragraph of this article. On the first paragraph of the article, it talks about how partnership is liable. Number 1. By any act appropriate for winding up partnership affairs or completing transaction unfinished at dissolution. So obviously, ito ang pangyayari since hindi mo nga natapos o di natapos ng partnership yung transaction na pinasukan mo bago ma-dissolve. Next is, by any transaction which would bind the partnership if dissolution had not taken place, provided the other party to the transaction had extended to the credit prior to dissolution and had no knowledge or notice of the dissolution. Ito yung mga taong nagpautang sa partnership which have no knowledge or notice na magdi-dissolution na sila. Kaya magiging bind pa rin ang partnership since wala nga silang knowledge na mag-dissolve na yung partnership. Next is, though he had not so extended credit had nevertheless known of the partnership prior to dissolution and having no knowledge or notice of dissolution, the fact of dissolution had not been advertised in newspaper of general circulation in the place or in each place if more than one at which the partnership business was regularly carried on. In this second paragraph, parang konektado siya dun sa paragraph number 2 ng first paragraph. The liability of a partner under the first paragraph, number 2, shall be satisfied out of partnership asset alone, when such partner had been prior to dissolution. Number 1, unknown as a partner to the person with whom the contract is made, and number 2, so far unknown and inactive in partnership affairs that the business reputation of the partnership could not be said to have been in any degree due to his connection with it. Bale, ang sabi lang dito sa paragraph number 2, need na satisfy nung condition ng number 2 in which kung na-satisfy mo o present ang dalawang ito, is yung mahabol lang sa'yo kapag nag-dissolution is yung partnership asset. Kung hindi mo naman ito na-satisfy, bukod sa partnership asset, pwede din mahabol o makuha sa'yo yung personal asset mo. On the next slide, ito naman nagtatackles about the partnership is not liable. The partnership is in no case bound by any act of a partner after dissolution. Number 1, where the partnership is dissolved because it is unlawful to carry on the business unless the act is appropriate for winding up partnership affairs. Sabi naman dito, since unlawful na ang business mo, it will not bind the partnership in connection naman sa winding up, pwede mo siyang i-continue as long na tungkol ito sa pagwa-wind up ng partnership affairs. Next is where the partner has become insolvent. The second one that will not bind the partnership by the act of partner is where the partner has become insolvent. Kapag insolvent, it will not bind the partnership since wala na siyang capacity to act. Next is where the partner has authority to wind up partnership affairs except by a transaction with the one who had extended credit to the partnership prior to dissolution and had no knowledge or notice of his want of authority, or had not extended credit to the partnership prior to dissolution and having no knowledge or notice of his want of authority. The fact of his want of authority has not been advertised in a manner provided for advertising the fact of dissolution in the first paragraph, number 2. Partnership is liable. Number 1, act appropriate for winding up partnership affairs. For example, the partnership of ABC was dissolved. Thereafter, B sold the remaining goods or inventories as well as the properties and equipment. In this case, transaction of B is binding to partnership. Number 2, act for completing transaction and finish at dissolution. An example for this is the partnership of A and B was dissolved. Thereafter, B transported to X, a client, the undelivered goods and inventories by virtue of a previous contract of sale prior to the dissolution. Liable ang partnership dito since yung transaction is made before the dissolution. Kaya kailangan nila i-deliver yung goods and inventories kay X. Next is any transaction which would bind the partnership if dissolution had not taken place provided the other property to the transaction A had extend credit to the partnership prior to the dissolution and had no knowledge or notice of the dissolution. An example for this is the partnership A, B, and C was dissolved prior to dissolution. B entered into a contract of sale with X by buying goods of the latter on credit, which is connected with the dissolution. In this case, hindi naman alam ni X na na-dissolve na yung partnership nila B. Kaya si X is in good faith. Therefore, the partnership is still liable to the contract of sale. Next is B. Though he had not so extended credit, had nevertheless known of the partnership prior to the dissolution, and having no knowledge or notice of dissolution, the fact of dissolution had not been advertised in a newspaper of general circulation in the place at which the partnership was regularly carried on. Example for this is the partnership of A, B, and C was dissolved. X is the supplier of the partnership even prior to dissolution. After the dissolution, C entered into a contract of sale with X by buying goods of the latter on credit, which is not connected with the dissolution. Dito katulad lang din siya nung nauna na wala siyang knowledge about sa dissolution, kaya magiging liable pa rin yung partnership. But if yung dissolution had been advertised sa newspaper of general circulation, yung partnership ay hindi na magiging liable. Go to the last topic. Partnership is not liable. 1. Where the partnership was dissolved because it was unlawful to carry on the business unless the act is appropriate for winding up partnership affairs. The example for this is the partnership A, B, and C was dissolved because of the alleged herbal medicine they were selling and declared unlawful by the Department of Health. Thereafter, B sold some of this to X. In this case, partnership is not liable. Since yung business nga nila is unlawful, hindi na binabind, it will not bind the partnership. Pwera na lang, if the winding up, in connection in winding up, you can continue as long as it is about the winding up of partnership affair. Next is where the partnership has become insolvent. Example for this is the partnership of A, B, and C was dissolved because C turned insolvent. Thereafter, C entered into a contract with X. In this case, partnership is not liable. Since C is insolvent na, wala siyang kakayahan na maglabas pa ng pera. Since bankrupt na nga siya. Kaya ang partnership ay hindi na magiging liable. Last is where the partner had no authority to wind up partnership affairs except by a transaction with a third person who is in good faith. Just like in last example, in partnership is liable though we had not so extended credit, hindi magiging liable ang partnership if it advertise sa newspaper of general circulation ang pag-dissolve ng kanilang partnership. And that's all. Thank you for listening.